And welcome back. You're watching African Perspective here on SABC News Channel. South Africa's Public Protector Advocate Mkhwebane, who's also the president of African Ombudsman and Mediators Association, joins us now to talk about the continental body and some of the challenges the public protectors face. And of course, we were just to round off some of what we're discussing here at home, Public Protector. Obviously, you are the president of this AOMA association, and you would have personal experiences to share. And I went back to some of the criticism against you. Some would raise the issue that they believe you are more securocratic in your approach of the law as opposed to be focused on social justice. How would you respond to that criticism?
I think the institution of ombudsmanship, the way we do our work, inquisitorial approach in our work. We are not accusatorial. And when we work as an institution of ombudsmanship, is a situation where we would have an approach where we bring the parties together, for instance, mediating or having an alternative dispute resolution mechanism. Or sometimes when we have a finding that a person has suffered prejudice. You know, there's one word we normally used in the past, the sorry money, where if we feel that a person is prejudiced, the ombudsmanship, even internationally, you can then say, but as a state institution, you have prejudiced this person has suffered so much. It's not a delictual liability, but then can you make sure that you put this person in a position which they are supposed to be? Therefore, in South Africa, the challenge now is that you have these findings which the Constitutional Court has decided that they are binding until set aside by a court of law. So when taken on review and the binding nature of the remedial action, that's where then we have these discussions and a lot of issues which are picked up. But in a normal state of events is that when we do our investigations, we should be working with the institution which should assist us in the investigation, so that at the end of the day, whatever remedial action we are coming up with, it's something that institution will be able to be implementing.
So let's talk about the value of remedial action. To your mind, especially given the powers of the ombudsman, you say there's different interpretation here at home and other African countries. What do you see it as? Should people be allowed to take the findings on review, judicial review?
Definitely. I mean, we are a constitutional state, and, you know, we believe in a rule of law. Any person who feels that they need to take our remedial action on review, they are free to do that. But in South Africa now, the Constitutional Court judgment is saying until set aside by a court of law. Therefore, that issue of interdicting then the implementation, that's the only available avenue for you to stay the implementation. Unlike in the appeal process, because the appeal, once you appeal, then there's that argument that the implementation will be stayed. But in a review process, we still expect that institution to implement the remedial action until we are interdicted in that particular aspect.
Okay, so help me in my understanding of the law. Am I taking your findings on review? Does that not automatically stop your...
No, it doesn't.
So it doesn't do that?
No, review is different to an appeal.
Okay.
Review, it doesn't until
but
you interdict.
It does test the rationality of the remedial action, am I correct?
Definitely.
So then how do you come to a conclusion that the remedial action is appropriate if it's not tested before a judicial
Interdict
process?
it. Interdict. And then it's not implemented. Why do we have a remedial action which the Constitutional Court said it's binding until set aside? So if you want us to stay the implementation, then interdict that particular remedial action.
Earlier on during an interview, you spoke about the importance of the judiciary, impartiality of the judiciary. What big role does that play then in assisting the Office of the Public Protector?
You know, the judiciary is there to make sure that we have, the issue of access to justice, and there is a way of applying the law, because they also need to hear from all the sides. I mean, if a person is taking us on review, if the public protector is opposing that particular review application, it doesn't mean the public protector is fighting, but the public protector would want to bring their own side of the story to assist the court to check both sides, you know, the side of the person, the litigant, and the side of the public protector. Therefore, if then there's objectivity in assessing both sides, especially on the merits of the matter, especially on what are the findings, what are the remedial actions which the public protector has taken, and for the court then to decide this needs to be set aside. And normally when a matter is set aside, a review should be taken back to the person, in fact to the public protector, so that then you can come up with other remedial actions which are regardless, or which will be proper according to, if the court is saying these remedial actions are not rational, for instance. Therefore, go back and produce or
So in an earlier interview, you mentioned the fact that questions ought to be asked about the independence of South Africa's judiciary. What was that born out of?
Everyone, the public protector is performing their work, they are independent, the judiciary is independent, that's what I've mentioned. But what I was saying is that if then there is a judgment by a lower court, the higher court can come up or have a different conclusion to it. The main focus should be on objectivity, because
so how do you measure that then?
Objectivity is taking both sides of the explanation or of the story, making sure that you as a judge, you decide purely on the application of the law. You don't discuss decide on what is the narrative out there, because as a judge you'll have to check the facts and you apply the law to the facts, whether the interpretation of the Public Protector Act has been properly followed, whether the interpretation of, let's say it relates to the application of the Public Finance Management Act has been properly implemented, whether the Constitution or the provisions of the Constitutions have been properly implemented. So it's purely relating to that.
Do you have faith in the independence of the South African judiciary?
The judiciary, I have faith in the partiality of the judiciary, but then we cannot just generalize, because there are some judges whose judgments are questionable, and there's nothing stopping us from questioning those judgments, because their judgments also are subject to higher courts.
No, absolutely. And do you have some in mind as in that would have made you raise these questions? Because some would assume that it's inbuilt in the Constitution, in the system, that judges are insulated from being swayed by either public opinion or issues on the particular cases that they work on.
Yeah, I have several of them. I mean, the CX judgment, for instance, as I'm saying to you, it was purely focusing on the side issues. And the way that litigation was done, I was only given 2 days to prepare the affidavit. Actually, a person is given around 7 days for you to submit your affidavit. But then there was a lot of pressure which was put on the public protector to come up with that, because it was 3 review applications. I've also mentioned in the issue of the Mkhwebane matter, I mean, the judgment there, the way the conclusions of the judge, which we've taken on appeal. But then the interesting thing was that before the cost order judgment, we were told, no, don't appeal now, wait for the cost order judgment so that you can lodge a comprehensive appeal. Then it means it was a premeditated or the pre-decided judgment. those are the examples, several of them, which I can give, especially the judgments which have taken place in the Pretoria High Court.
So it would be the North Gauteng High Court in particular that you would say you have issues in its ability to carry out its...
Yes, and I've raised it with the Judge President because we were supposed to have a meeting and I was not questioning that. I know when it comes to judgments, yes, the higher court will have to decide on that. But again, the way some of the decisions are taken, the way, I mean, the rules, if you are supposed to be given 21 days to prepare or to submit an affidavit, that should be done. You shouldn't be then given lesser dates. You shouldn't, I mean, with the CX matter, the councils which I was using, some of them were supposed to be acting as judges in December. We requested the postponement to the following year, but then the acting judge or the judge who was hearing that matter refused to do that. The very same judge was the same judge who refused the postponement, but was the very same judge who then continued to decide, or was part of the judges who decided on
Advocate
the matter.
Mkhwebane,
so those are the issues.
Hold the thought. I want us to talk about those challenges and how they apply to IOMA as well, how the African Ombudsman body can improve going forward on the continent. We are in conversation with South Africa's Public Protector, Advocate Mkhwebane, who is also President of IOMA. Don't go away. We'll be back shortly.